Written and unwritten sources of law of persons. Under Turkish law, there are various sources of law, including written and unwritten sources. The written sources of law of persons are the Constitution, legislation, international conventions, presidential decrees, and bylaws. Unwritten sources of law of persons are customary law, doctrine, and judge-made law. Written sources of law of persons. The Constitution. The Constitution that contains rules about essential institutions of the state, fundamental rights, and freedoms of individuals is also one of the primary sources of the law of persons. The Constitution has a position at the top of the pyramid of the legal order, and they are the highest level and fundamental statutes of the states. Article 11 of the Constitution provides that the provisions of the Constitution are binding for the legislative, executive, and judicial organs, and the administrative authorities, other institutions, and persons. Legislations and other regulations cannot be contrary to the Constitution. All legislation must be in harmony with the Constitution. If legislation is in conflict with the Constitution, it is abolished by the Constitutional Court. Presidential decrees. According to the Constitution, the President is the head of the state, Cons. Art. 104, Para 1. The President can issue decrees. Presidential decrees may not contradict the Constitution and the laws. The Constitutional Court reviews the constitutionality of presidential decrees. There are two types of presidential decrees: ordinary presidential decrees and extraordinary presidential decrees. Types of presidential decrees. Ordinary presidential decrees. The President may issue a presidential decree on matters relating to executive power. However, the Constitution limits the subject of decrees. Such decrees cannot be issued on any matter. The fundamental rights, individual rights, and duties and the political rights and duties in the Constitution cannot be regulated by the presidential decree. Accordingly, fundamental rights and freedoms such as housing, immunity, communication, travel, religion, thought, science, art, press, property, etc., cannot be subjected to presidential decrees. Presidential decrees may not contradict with the laws. If a presidential decree and the law have different provisions on the same matters, the provisions of the law are applied. Where the Grand National Assembly of Turkey enacts a law on the same matter, the presidential decree becomes void. The Constitutional Court reviews the constitutionality of ordinary presidential decrees. Extraordinary presidential decrees. In case of a state of emergency, the President may issue presidential decrees on the matters required by the state of emergency. Unlike ordinary presidential decrees, the fundamental rights, individual rights, and duties and the political rights and duties in the Constitution can be regulated by the extraordinary presidential decrees. The extraordinary presidential decrees have the force of law. However, unlike ordinary presidential decrees, the Constitutional Court cannot review the constitutionality of ordinary presidential decrees. Unwritten sources of law. Court decisions. Court decisions are a significant source of law in Turkey. The courts, specifically high courts, play an essential role in interpreting, applying, and developing the legal text. Court decisions have a fundamental role in developing the law of persons in Turkey. Courts, through their decisions, shape the law. Decisions made by the higher courts have significant effects on lower courts. Some decisions of higher courts are guiding, some are binding and therefore a source of law. Customary law. Concept of customary law. Another unwritten source of law is customary law. Customary law results from general and constant practice of people. As a source of law, violation of customary rules could attract sanctions. Custom in this sense means something more than mere habit or practice. Customary rules are the behaviors which have roots in the community for a long time. The criteria for determining customary law. For a rule to become customary law, three elements must come together. These three elements are the material element, spiritual element, and legal element. The material element, continuity. The material element of customary law is continuity and repetition. For a practice to be the customary rule, it is necessary that people must have practiced it for a long time. Temporary repetitions that do not show a stable situation do not gain the character of customary law. For this reason, the event has to occur on an unknown date. The spiritual element, general belief. The spiritual element of customary is a general belief. It refers to the inner conviction that a tradition is binding and obligatory. There must be a feeling among the people who practice it that is necessary to comply with the rule. In other words, people must accept this practice as a rule of law. If there is no such belief in the conscience of society, no matter how continuous a tradition, it cannot gain the character of customary law. For judge-made law. A judge's duty is not to make law, but to apply the laws made by the parliament. While deciding, judges apply the laws and the case law of higher courts. However, there could be situations where there is no express law to apply the case. In such a case, the judge would decide in a way that he would make if he were a legislator.